Next case set for argument is State of Ohio versus DeMarcus Shealy. It is case number 29-393. Both parties are represented by counsel. As each of you know, you'll have 15 minutes to argue before the court. They reserve up to 5 minutes. You've seen our timing system, right? Okay,
yes.
So you know how that works. We've read the briefs and we are prepared to proceed if you are.
Okay, thank you. And I can reserve 5 minutes, please. Okay. Your Honor's opposing counsel may please report. Attorney Angie Killey on behalf of the appellant, DeMarcus Shealy. In regards to Mr. Shealy, I would like to focus on assignment of error number 3 in my brief. And that is a question of whether or not the trial court erred when it overruled defense motion for Rule 29 as it relates to the obstruction of justice charge. At the time of the close of the state's presentation of evidence, trial counsel did raise the issue of a Rule 29 motion as it relates to obstructing justice as a felony of the 3rd degree in this case, where ultimately Mr. Shealy was convicted. Trial court decided that there was some facts that would indicate that he hampered or impeded and that it was a question for the jury. Our position is that it never should have gone to the jury because it is contrary to the plain language of the statute. When you review the statute that he was convicted under, which is RC 29-2132A, it says no person with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for a crime or to assist another to the benefit of the commission of the crime shall do any of the following: communicate false information to any person. And first and foremost, our position is that Mr. Shealy did not give false information. What he did was fail to give information when he was requested information. But the simple truth is that they were investigating him. There is nothing in the record that indicates that they were trying to investigate or charge anybody else and use him as a witness. They were looking at whether or not he should be charged with a crime. So I believe that the plain language of this statute is written in that fashion because when police are questioning you about an investigation into yourself, there's Fifth Amendment implications that come up. In reviewing the prosecutor's brief, I know that she asserted my comparison to the federal statute or the federal case law, and yes, I'm aware that the state of Ohio has not adopted that case law. It's our position that the state of Ohio needs to adopt something similar if the prosecution is going to try to utilize a statute in this fashion because there are Fifth Amendment implications. And if you look through the record, the information that was presented by the state during the testimony of one of their witnesses as it relates to obstructing justice is around like the 374 to 376 range. And the detective or officer that was on the stand basically talks about that he only identified one of the 5 people in the car. That he initially said that he was outside of the building when the shots were fired. And that he didn't admit to hitting somebody with a brick until after he was arrested. Well, how is that hampering or impeding an investigation into another person? He's giving questionable statements or lacking information as it relates to the investigation of himself. The
Counsel,
yes.
arguably, I think more than arguably, I mean, if we all agree, your client's not the one who pulled the trigger. Do I
Correct.
have that correctly? Arguably, one of those other people actually pulled the trigger.
I can't recall anything in the record where they questioned him about that specific individual. And we're looking for that. They were simply looking for information about who else was present and what his involvement were, and the information that they pointed to for their conviction in the prosecutor's testimony was like, he didn't tell us that he hit somebody with a brick until after he was arrested.
You don't think that when there is a dead body there and they ask who else was present, they're not actually investigating the others as well? I absolutely understand your argument in terms of not others and the plain language of the statute, but don't you think they were actually investigating the others here?
Well, I suppose there could be some argument that they were investigating potentially everybody that's in the car, but I think that in Mr. Shealy's case, because he was obviously being investigated, that it doesn't matter. Because he's still, he didn't have any obligation to speak to the police at all.
And is a part of your contention because the focus of their questioning was all about Mr. Shealy's role?
Correct. And I think that it needed to be questioning in regards to another individual. Because to me, it presents a catch-22 22, if I invoke my Fifth Amendment rights, I get charged with obstructing justice. If I tell you that I per se murdered somebody, you're gonna arrest me and charge me with that crime. So it's infringing on his ability and his decision-making. And I know that the state also presented the argument that it wasn't raised specifically at the trial level, so it is waived. I would respectfully disagree with that position because trial counsel did specifically raise the issue of the obstructing justice in the 29, although not this precise language of the statute that I'm addressing. However, I think that it's all encompassing of the entire conviction, but if the court feels as though that was waived as a result of him not specifically arguing this section of the statute, then I would argue that it is plain error because it violates the plain language of the statute. And it doesn't need to go any further than that. I really feel as though this is a slippery slope that infringes on people's Fifth Amendment right if it continues to move in that fashion. So, that was really my primary focus for purposes of today. If there are questions about other assignments of error, I'd be happy to entertain those, and if not, I would rest on my brief.
Anything else? All right, thank you very much.
Thank you.
You'll have a full 5 minutes for rebuttal.
Okay, thank you.
15 minutes, Counsel.
Thank you. May it please the court, I'm Jacqueline Corrigan on behalf of the state of Ohio to urge this court to affirm Mr. Shealy's convictions. Starting off where counsel left off with assignment of error number 3 concerning the sufficiency of the evidence that supports the obstruction of justice conviction, I would remind the court that while the detective seemed to focus on Mr. Shealy during the trial, he was giving evidence concerning the investigation of Mr. Shealy for the purposes of the trial, not to explain the purposes of the investigation. However, the detective also detailed some of the other details of the investigation in general, in which he noted that Mr. Patrick had identified Mr. Shealy and at least 2 other people as being involved in this case, but that Mr. Patrick did not see who actually pulled the trigger and shot Mr. Bradford, causing his death. Police were investigating all of the individuals who were involved. Police were aware that there were several individuals involved because they had, during the course of their investigation, found a videotape from a church nearby, near the apartment building where this occurred, just showing Mr. Shealy's cousin exiting a blue Dodge Neon with 4 other passengers. So the police were trying to find out who those people were and who among them may have pulled the trigger and killed Mr. Bradford. So the focus of this investigation was not solely on Mr. Shealy, it was on the totality of the circumstances of this murder.
Doesn't that impact his Fifth Amendment right, though, as opposing counsel said, if he answers the question, he's likely to implicate himself either directly or as a complicitor in a rather serious charge. I mean, there's a person that's dead in the apartment, and he has a right not to answer the questions, doesn't he, under the Fifth?
Well, he wasn't in custody, so Miranda didn't attach, and I would remind the court, though, that the principle that counsel is adopting this court, or is urging this court to adopt, the exculpatory no concept, I would urge this court not to adopt that, since it is a concept that the Supreme Court of the United States has rejected explicitly. And so there's no reason for Ohio to adopt a line of reasoning that the Supreme Court of the United States has rejected. Moving on, though, to address some of the other assignments of error, I would like to touch upon the manifest weight of the evidence, which was assignment of error number 1, and to explain to the court what the jury was entitled to believe in this case, and explain why the jury did not lose its way and create a manifest miscarriage of justice, which also touches on the obstruction charge. On April 16, 2018, Mr. Bradford, just to go through some of the facts underlying this, Mr. Bradford did attack Mr. Shealy at Mr. Patrick's apartment over a $10 debt, and then Mr. Patrick kicked Mr. Shealy out of his apartment. That was the very day that Mr. Shealy had been in a pretrial concerning a different case that is attached to this one, for which he was also sentenced. Because 1 year of the 27-year to life sentence that he is serving comes from that case. So Mr. Shealy leaves the apartment, calls his cousin for a ride. She arrives in the blue Dodge Neon with 4 passengers. They get out of the car. Mr. Shealy is angry about having been disrespected. The passengers get out of the car. They one way or the other, they get to the door of this apartment building where Mr. Shealy wants revenge. So he picks up a brick with the specific purpose of getting revenge on Mr. Bradford. He's yelling at Mr. Bradford to come outside. Mr. Patrick is begging Mr. Bradford not to leave the building. Mr. Bradford instead opens the door to the building, whereupon Mr. Shealy strikes him with the brick. He strikes him at least once, that we know, because there are at least 3 abrasions, probably from a brick, on Mr. Bradford's face.
Were they the only 2 in the immediate vicinity at the time he was struck with the brick?
Pardon, I missed
Where
that.
was it a one-on-one confrontation there, or were the others present as well? The
Well,
cousin and the people in the Neon?
The others, at least 2 of the others, Mr. Rankins, who actually pulled the trigger, and one of Mr. Shealy's other cousins, had to have been very close behind it, because when Mr. Bradford gets hit in the face with the brick, he starts backing into the apartment building, and that's according to the physical evidence of the blood that he leaves behind. And so he backs into the building, and Mr. Shealy, his cousin, and Mr. Rankins at least follow him into the hall and into Mr. Patrick's apartment. Mr. Patrick doesn't see the actual shooting, and neither does Mr. Cephas, the neighbor, because Mr. Cephas opens his door, sees the gun, and these individuals, closes his door in fear. Mr. Patrick, though, runs across the street to try to get a phone to call 911.
So where I'm confused is, did Shealy hit him with the brick and then leave the scene?
That's the 4th version of the story that he tells the jury at trial. What the jury was entitled to believe, though, was that he followed these other 2 as they pursue Mr. Bradford back into Mr. Patrick's apartment, because the bloody brick is left in Mr. Patrick's apartment. That's where it's found. And in at least one statement to police, Mr. Shealy says that Mr. Rankins is the one that pulled the trigger. Now, at trial, he says that he heard all that from the cousin who drove the Neon, but he told police that it was Rankins that pulled the trigger. So, after Mr. Bradford is shot, Shealy leaves the scene on foot. Rankin and the rest of Shealy's cousin's passengers leave in the Dodge Neon. 5 days later, after the murder, Mr. Shealy tells police that his cousin had arrived alone, that there was no one with her. That concealed the identity of the shooter for that period of time. 13 days after the murder, Mr. Shealy names Mr. Rankin as the shooter. So Mr. Rankin's identity is concealed from police officers for 13 days. And then finally, after police confront Mr. Shealy about it, Mr. Shealy admits a month after the murder that he had hit Mr. Bradford with the brick. So that was what the jury was entitled to believe, and also that met the sufficiency standard for the obstruction as well. I just want to touch very briefly on the other 2 assignments of error concerning sentencing. Counsel had raised an issue about the use of a pre-sentence investigation report that had been created about 4 months before Mr. Shealy's trial. It was created in anticipation of his sentencing after he had entered a plea to a lesser charge. He then withdrew his plea and went to trial, and the PSI that was in existence at the time after he had pled was the one that the court considered in imposing sentence. The objection to the PSI was, or to the use of this PSI, was that Mr. Shealy had, for lack of a better way of explaining, he version number 3 of, or his version number 3 of events in the PSI. At trial, he tells version number 4, in which he said that after Mr. Bradford backed into the hallway, he left and didn't see any of the ensuing events. The trial court told Mr. Shealy that she found that bolstered his testimony at trial, that he lies depending upon the situation and depending upon whether he thinks he's going to get in trouble for what he says, or whether the truth will cause him to get into trouble. So there's really no case law to support that there's an expiration date on a pre-sentence investigation report.
Did the defendant request an additional pre-sentence report after he was convicted and prior to the sentence?
I don't recall that he did in the record.
Did the court offer?
I don't think the trial court offered either. So the PSI was the PSI. But really, even if a PSI had been redone, the basic information would have remained the same. All the same police reports that were part of the PSI would have been there. The same criminal history would have been there. Everything else except possibly, well, if it had been redone, there might have been an additional statement from the defendant. I don't know whether that would have substituted for his previous statement, however. So I would argue that the use of this PSI was not actually harmful to Mr. Shealy. And then finally, as to the fourth assignment of error concerning the lack of self-defense instruction, no matter who bore the burden of proving the elements of self-defense, whether it was the state, whether it was Mr. Shealy, and our argument was that it is not a retroactive statute, so that Mr. Shealy bore the burden of showing the elements of self-defense, but that no matter who bore the burden of proof, Mr. Shealy created the affray that led to Mr. Bradford's death by challenging Mr. Bradford to come out of the building, and he admitted he wanted revenge, and then he picked up the brick to use against Mr. Bradford. So that in itself negates one of the key elements of self-defense. And so under those circumstances, the self-defense instruction would have been wholly inappropriate, and the judge did not abuse her discretion in rejecting that.
All right, very good, thank you.
Thank you very much, and I urge the court to affirm.
You. Counsel, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. As to address the issue that the state brought up in regards to the PSI and her arguments, first and foremost, Judge Teodosio, to answer your question of did the defendant request or was there one offered, the answer is no. The defendant never had an opportunity to request, because if you look at volume 5 of 6, on page 626, as soon as he was convicted, the court says she had a PSI from the prior where he pled guilty, that she would give them a couple of days if needed to prepare, but won't order a new PSI. Very specifically said it's not an option for the defense to do that. I feel as though the state makes an issue of whether or not he's doing the same statement as his third version or his fourth version or however it goes from that. But the reality of the situation is that a pre-sentence investigation is a self-serving document. At the time he admitted to a crime, and as admitting to that crime, of course, part of the PSI process is that he's required to give a statement. I have no doubt that his incredibly competent trial counsel advised him to give an admission to the offense as a result, like a trial tactic that we often use in order to mitigate the effects of sentencing. And when he went in front of Judge Croce and had a full hearing, he vacated his plea, very clearly stating that he didn't commit the offense. He was once again asserting his innocence, and our position would be that under those circumstances, that any and all prepared statements for the court should not have been allowed to be considered. Judge Croce could have looked at the statements that he voluntarily gave to police in making a determination that his sentence should be stronger, but that's not what she did. She explicitly said that the statements made in this pre-sentence investigation were part of the basis for giving him consecutive sentences because she felt that he was being untruthful from the court. And in regards to the argument that it could have resulted in maybe an additional statement or a confirmation if a new one had been made, I suppose there's some truth to that, and from a trial tactic, I would also say that 9 times out of 10 what I see is we're gonna appeal, please don't give a statement on your pre-sentence investigation is what is advised. And therefore, there likely would have been no additional statement because he was asserting his innocence through this entire process.
Counsel, you said that the court said, I won't order another pre-sentence investigation.
Correct.
And did defense counsel object and say, look, Your Honor, I think there is one needed?
No, I don't believe so. If there are no other questions, then I would rest.
All right, thank you both for appearing today and providing the court with these arguments. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail you each copy of the decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. But once again, thanks for taking the time to come down and argue the case for us.